Hello, everyone. We are just going to let people filter in. I can see folks are joining us now, and we'll get started shortly. So it looks like we've got almost 140 people in the room. We're still expecting a few more, but while we wait for everyone to join us, we'll do some housekeeping and introductions. I am Julia Martin from the Bruman Group. I'm joined with Michael Brustein, one of the firm's founding partners, and we are very excited to talk to you today about Title IX. Welcome to the Tennessee District's Title IX training. Today's virtual training will consist of a 2-hour presentation with time for questions. If you have any questions during the training, you may type your questions into the Q&A tab found on the right-hand side of your screen. Any new or unanswered questions can be found under the All tab. These questions may be taken during the presentation as time allows, or we'll try and respond to them after the presentation has concluded if we do not have the ability to do so as we are moving. If you experience any technical difficulties, please feel free to contact us via the technical support chat. We have our wonderful tech support person, Evelyn, here today to answer your questions and help with some logistical concerns. You can also email us at webinars@bruman.com. That's webinars with an S at BRUMAN.com. For a copy of today's handout as well, you can download it from the Handouts tab in the top right-hand side of your screen. It's a PDF file named Title IX K-12 Staff Training 2024. So with that, let's get going.
Let me just quickly say good afternoon. Julia is broadcasting from her home just outside the district in Tacoma, Maryland. And I'm joining her today really as her assistant. And I am broadcasting from Mendocino, California, where we just had the power restored last night. But I'm looking forward to this as well, Julia.
Michael was so eager to be on this training that he pulled all his strings with PG&E.
Right.
All right, so let's get started. I want to start with a couple of disclaimers. So this training is a required training for the regulations for Title IX in 34 CFR 106.45 and some related context. It's not a comprehensive Title IX training. We're going to try and answer as many questions of yours as we can and balance that with some efficiency. The materials are provided, they're in the Handouts tab, and they may be posted publicly to comply with federal regulations, which require posting of training materials. Please take this as our permission to post these materials. This training does not constitute an agreement of legal representation with us as attorneys, so do consult with your own counsel for any advice on a specific situation. Before we get into the nitty-gritty, these required training pieces, I want to start with some context about Title IX. And don't worry, this part is going to go quickly, so if you know exactly what Title IX is, and I saw that many of you listed Title IX Coordinator as your title when you registered. That's so wonderful. It won't be too painful. For the rest of us, many of us think of Title IX as the thing that controls athletics, but there are actually a lot of pieces and moving parts to it because Title IX at its heart is about discrimination on the basis of sex. And at the high school and the college level, we often find the conflict centers around equity in athletics or ability to create women's or girls' teams. It actually comes from Title IX of the Education Amendments of 1972. And those education amendments were enacted as a follow-up to the Civil Rights Act of 1964. It was originally applied to just those receiving direct aid, but in 1988, the Civil Rights Restoration Act extended Title IX coverage to all programs of any educational institution that receives any federal assistance, both direct and indirect. That means it applies to public and private schools that receive assistance at all levels of education, including elementary and secondary education, school districts of which any part receives federal funds, and collectively, this group of entities is known as recipients. So we'll talk about districts and recipients and entities somewhat interchangeably. The technical term, though, is going to be recipients. And I know Michael had some personal experience with some of this Title IX development.
Yeah, so thanks, Julia. When Julia was preparing the bios for this presentation for the Tennessee Department of Ed, she said, "Oh, Michael joined the federal agency to help write the Title IX regs back in 1874. Well, I know I'm old, but that was about 100 years off. So when I became a federal attorney in a former life, one of my first responsibilities was working with a team of lawyers and actually drafting the original regulations under Title IX. What I wanted to briefly explain, though, is how Title IX came about. So when Congress was considering the Civil Rights Act, as Julie mentioned, back in 1964, the key provision impacting education was Title VI, that no person would be discriminated on the basis of race, color, religion, or national origin in any program receiving federal financial assistance. Congress considered adding gender to that provision in Title VI, but they did not. They actually added it to Title VII of the Civil Rights Act of 1964, barring discrimination on the basis of race, color, national origin, and sex in employment in the United States. But it was really 8 years later in 1972, and at that point in time, every 2 years, Congress would pass what was called the Education Amendments of 1970, 1972, 1974. And when they enacted the Education Amendments of 1972, one of the titles, Title IX, had the standalone provision that we're going to be talking about this afternoon, barring discrimination on the basis of gender in programs receiving federal financial assistance. Interestingly, that provision, Title IX, has very, very little legislative history. If one were to research, well, what was Congress thinking when they enacted that back in 1972, there really is no amplification in the reports from the U.S. Senate or the House. It was just added really without controversy. But when you look at the major provisions dealing with discrimination on race, gender, and disability, it is the one on gender which now is causing the most amount of interest and challenges that we're seeing across the country. So with that, Julia, I'll just turn it back to you. I don't want to waste time. I know you've got 92 slides to get through.
Yes, we're going to be busy today. We're going to move quickly. Thanks, Michael. And I just wanted to flag the Tennessee Department of Education has let us know that they are going to add closed captioning to the video recording. So anyone who would like to view that with or who needs to communicate via ASL can view that training down the road. So let's get back to the 1970s. This is the key language in Title IX, which says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. That's it. That's the provision that we're talking about today, which has generated, as Michael pointed out, 90-some slides. But Congress may not be verbose. That does not mean that the Department of Education is not verbose. And they have structured a regulatory system which in their view is the way to facilitate this equity of access and participation. So in the Department of Education's view, as part of this, Title IX protects against discrimination in recruitment, admissions and counseling, financial assistance, athletics, sex-based harassment, treatment of pregnant and parenting students, discipline, single-sex education, and employment. It is enforced primarily by the U.S. Department of Education's Office for Civil Rights, but they only investigate and enforce when there is a complaint. Either there's an individual complaint or there's a pattern identified in the Civil Rights Data Collection, or CRDC, that starts to raise some concerns about systemic issues. So the weight is primarily on the shoulders of recipients to make sure Title IX is being followed and conduct procedures accordingly. Title IX investigations are actually very much centered on sexual violence, sexual harassment, and retaliation. We'll talk about that concept as well. There are a handful of complaints that the U.S. Department of Education receives about discipline, gender harassment, dissemination of policies, but really between athletics, following the procedural requirements, and sexual harassment, sexual violence, and retaliation, those are the big issues that come before the U.S. Department of Education, and those are some of the ones that we need to be very scrupulous about knowing and following the rules. So every recipient needs a Title IX coordinator. We have these pop-up attendance questions. So it's part of the way that we can check to make sure you're still here, you're still awake. If you need another cup of coffee, absolutely, you should have one to stay awake. This is our first, do you know who your Title IX coordinator is? Yes, it's me. Yes, it's someone else. No, but I'm sure we have one. Or my what? So let's see how we're doing on that question. As people, oh, we've got a lot of Title IX coordinators here today. 60% of our respondents are Title IX coordinators. I'm so glad. Many of you say it's somebody else. I only see one that said you're not even sure what that is. If that was the response that we have, then I'm so glad you're here because you're going to learn. And then those of you who say no, but I'm sure we have one, we're going to learn more too. And I also see everyone's introducing themselves in the chat. That's great. It's so nice to see folks virtually from so many places across the state. So each Title IX coordinator is responsible for helping to ensure the recipient's compliance with Title IX's administrative requirements, all of the paperwork. They must have knowledge of the recipient's policies and procedures on sex discrimination, should be involved in drafting and revision of policies and procedures, should be involved in Title IX involved disciplinary and other proceedings and monitor outcomes, monitor athletic participation, provide training and professional development, among other responsibilities. So this is quite a big list of responsibilities. I know that everybody who is the Title IX coordinator knows it's a big job. And those responsibilities do have the potential to get added to as the process moves along. So who is a recipient and who needs a Title IX coordinator? The Department of Justice has said that the term recipient is any state or political subdivision to whom federal financial assistance is extended directly or through another recipient, and notes that you don't just have one recipient in a federal program like Title I. You can have multiple recipients and subrecipients. DOJ is full of lawyers. The Department of Education has said it a little bit more plainly in their regulations, noting that the rule references elementary and secondary schools, but elementary and secondary school here means a local educational agency or LEA, a preschool, or a private elementary or secondary school. So for public schools, the responsibility sits at the LEA levels. For preschool or private schools, the responsibility remains at the school level. And then, of course, the SEA is a recipient as well.
So, Julia, I just want to add a footnote here. You mentioned earlier the Civil Rights Restoration Act of 1988. So, what actually happened, and it's really interesting because this issue of who is a recipient went all the way up to the Supreme Court. The Supreme Court ruled on it, and then Congress overruled the Supreme Court, which rarely ever happens. But in the mid 1980s, a college, Grove City in Pennsylvania, uh, said they are not subject to Title IX because none of their programs received direct Title IX assistance. And it went through the federal district court and the Court of Appeals. And it was appealed all the way up to the Supreme Court. And the Supreme Court determined that only those employees of Grove City College who actually worked in the student financial aid office were subject to Title IX. None of the other programs or activities at the college received direct assistance. They were not subject to Title IX. And that was the decision of the Supreme Court in the Grove City case. Well, 2 years later, Congress went ahead and overruled the Supreme Court, enacting the Civil Rights Restoration Act, imposing this very broad definition of who is and what is a recipient. And essentially, as Juliet pointed out, if a school district receives just $1 of federal funds from any federal agency, that would trigger being subject to Title IX. So it's interesting that this was litigated all the way up to the Supreme Court and then required the intervention of Congress. Back to you, Julia.
Thanks. So there are a handful of exemptions from Title IX, and I'm not going to go through these in detail, but I do want to note that these exemptions are not full exemptions from Title IX. There are situations where a school can get a partial exemption. If you are a recipient, Title IX as a rule applies to you, with some exceptions, like some single-sex schools if certain conditions are met, schools training individuals for military services, Girl Scouts, Boy Scouts, etc., social fraternities and sororities. And again, as you can see here, this exemption applies only in limited circumstances. So the application of Title IX is very broad. The exemptions are few and far between. The 2020 rule is very clear that the same rule applies to both K-12 schools and colleges, but there are some key differences from what you might have experienced as a college student or an administrator, and they're primarily driven by what is age appropriate. So sometimes when we see training materials and trainings, they are directed at colleges. I want to call out a couple of differences here because this is a training for K-12 staff and leadership. The first difference is anytime a K-12 school employee has noticed that sexual harassment or assault might have occurred, the school or district must respond. At higher ed institutions, the notification requirements are different, right? You have to notify the Title IX coordinator in order to prompt a response. So in K-12 schools, because kids are not able to always differentiate between who is the right person to talk to something about, because they may have a comfort level with someone who is, the lunch lady or the school nurse and is not their classroom teacher or the principal. We want to honor and respect that. The second is that K-12 schools may but are not required to conduct a live hearing. A written back and forth is enough, again, trying to respect the age, the attention span, and potentially the mental health ramifications of an incident. And then finally, a parent or legal guardian may act on behalf of a complainant or a respondent throughout the process for anyone under the age of 18. So why am I here? Why are you here? This is the requirement for training. A recipient must ensure that Title IX coordinators, investigators, decision makers, and any person who facilitates an informal resolution process receive training on all of these issues listed. So we are going to check all of these boxes except one today, And that box that we are not going to check is the one that says a recipient must ensure that decision makers receive training on any technology to be used at a live hearing. I don't know if you use technology. I don't know what kind it is. It'll vary from district to district. I think after 4 years, we all are familiar with Zoom and Teams and Google Meet. So I think that requirements for that training would probably be minimal, but I want to flag that that is something you need to make sure you have. We will cover the rest of it. So with that, here is our required training elements agenda. Definition of sexual harassment, what is an educational program or activity, how to conduct an investigation, the grievance process, how to serve impartially, relevance, creating an investigative report, and then I'm adding one more, which is what are the coming changes that we expect from the Title IX rule that the U.S. Department of Education is drafting, and when do we expect those changes? And we're going to get there at the very end. So we are going to talk today about the current rules. They are effective as of August 2020, and they will apply until the new rule takes effect. We don't exactly know what that date is just yet. And we will start with the definition of sexual harassment. Sexual harassment under the regulations is conduct on the basis of sex that satisfies one or more of the following. We're going to break this down in detail in the next few slides, right? One of the things I want to highlight on this slide is that it has to be conduct on the basis of sex. That requirement, that threshold needs to be met in order for something to be considered sexual harassment. So the first kind of sexual harassment is what we would call quid pro quo harassment. An employee of the recipient conditioning the provision of an aid, benefit, or service on an individual's participation in unwelcome sexual conduct. Now, this applies for both employee-employee relationships and employee-student or applicant relationships. So this is the first potential type of sexual harassment. The second, I think, is what we normally think of when we think about this grievance process, which is unwelcome conduct. But there's a high standard for what's considered sexual harassment here. Unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education, program, or activity. This is a really high bar here, right? We all think we're reasonable people. So we'll say, okay, I assume that I'm going to meet that threshold. But something that is so objectively offensive means everyone agrees it's bad. That's a high bar to meet. And that it has to be so offensive that it makes the other person unable in some way to participate in education. That's a lot of requirements to meet the definition of sexual harassment.
Yeah, and Julia, I just want to point out here that earlier versions of the definition of sexual harassment, when they were first promulgated back in the 1990s, used much more of a subjective test than an objective test. They simply looked at how did the conduct impact that individual, not what a reasonable person or an objective test would be. So this is an evolution of this particular standard, and I completely agree with you. As it stands now, it's a much higher bar to satisfy this particular prong.
Absolutely. So the other, or let's talk about what it means for conduct to be unwelcome. What is unwelcome conduct of a sexual nature? It is conduct without consent. The regulations don't require a particular definition of consent. It doesn't say whether it has to be verbal or implied, but they expect you to define it. The preamble to the regulation says that the recipient should choose a definition of consent, and therefore what is unwelcome or without consent, that best serves the unique needs, values, and environments of your own educational community. So this may be developmentally appropriate as a consideration. It may be something that aligns with other disciplinary policies. This is something that you should have determined and written down. We also want to look at what it means for conduct to be so objectively offensive that it effectively denies access. So the recipient in this case should consider whether a reasonable person in the complainant's position would be effectively denied access compared to a similarly situated person who is not suffering the alleged sexual harassment. Examples from the guidance include: does the complainant feel compelled to skip class? Is their GPA declining? Do they have difficulty concentrating? Do they quit school activities such as sports? Do they exhibit changes in behavior consistent with trauma that could impact their ability to participate or concentrate? There is no set threshold for what is enough, in part because that is very subjective as to what makes a person unable to participate individually. It also does not require either a concrete physical injury, like a diagnosis, for example, or a total denial of access, right? Those are not requirements or thresholds. We need to look at this at a case-by-case basis. The last type of sexual harassment is sexual assault as defined in these various rules. And we'll also put the language, we have the language in the slides that this references. So I want to note that we normally talk about this as sexual harassment or sexual assault, or sexual harassment and assault. But this rule defines sexual assault as a subset of sexual harassment. Just because it is considered a more severe offense does not mean that it is not considered sexual harassment. Along with dating violence, domestic violence, and stalking, those are all considered types of sexual harassment for the purposes of this rule. So we won't go through them in detail, but these definitions for your reference are listed here. Sexual assault under the Clery Act, dating violence, domestic violence, and stalking. Those are all types of sexual harassment. We don't need to meet every type of sexual harassment in order for a person to have a valid complaint.
So, Julie, just to be clear, sexual violence is a subset of sexual harassment, but sexual harassment is a subset of sex discrimination.
Yep, that's right.
Right. So, I mean, because when it all began, it was just simply sex discrimination. And in the 90s, they added sexual harassment. And in the early 2000s, they added sexual violence. So one is a subset of the other, just putting it into a perspective.
Yeah, thank you. So in sum, what we think of sexual harassment as is conduct on the basis of sex. Again, we have to have that requirement. That is quid pro quo, involving unwelcome sexual contact by an employee. Sexual conduct that is so significant it effectively denies access. They also refer to this as a hostile environment. Sexual assault as defined in the Clery Act, or dating violence, domestic violence, or stalking as defined under other federal law. Each of these is a different type of sexual harassment. As Michael pointed out, each of these is a different type of discrimination on the basis of sex, because it impacts a person's ability to participate in a program. So let's talk, this also applies to conduct among or by employees, as well as students, and employees may report directly to the Title IX coordinator. The other note in the preamble by Ed says that a power differential among employees or voluntary conduct among others may create a false impression of what is permitted within the scope of the activity. So if you have a supervisor or someone who is in a position of power, we want to be sure that there is clarity in terms of what is permitted and what is not permitted outside of that position.
So, Julie, even though the Clery Act is not directly applied to school districts, could you just take a moment to explain to folks what the Clery Act is?
Sure. The Clery Act is a federal law that requires colleges and universities to report on certain incidents, public student safety incidents on campus. And as a result, it defines specific types of behavior that need to be reported, and in what area those incidents occur when they need to be reported. So the idea is they're just pulling the definitions and incorporating by reference. It doesn't mean that you have to comply with the Clery Act. So what is an education program or activity? In other words, when this conduct occurs or where it occurs does impact your obligation to respond. An action must happen within a recipient's education program or activity to trigger that obligation. So except as provided elsewhere, right? We can't exclude folks from any other education program or activity operated by a recipient which receives federal financial assistance. The complainant either must be participating or attempting to participate in educational programs or activities of the recipient. This means that there are some cases in which an obligation is not triggered. If the conduct, even if proved, did not occur in the recipient's education program or activity, or did not occur against a person in the United States, then the recipient must dismiss. That does not mean that you can't take action under your own disciplinary policy. It simply means that you have to dismiss a Title IX complaint if it is not conduct that occurred within your education program and activity. There's no jurisdiction under Title IX. An education program or activity is locations, events, or circumstances over which the recipient exercises substantial control. That can be on campus or off campus. It can be any building owned or controlled by a student organization that is officially recognized by a post-secondary institution and is not the same thing as the Clery Act definition of on campus. So we mentioned the Clery Act. The Clery Act only requires that incidents that occur on campus be reported. And this is saying that our Title IX definition of what must trigger action is somewhat broader. That can include classroom buildings and, oops. So here's our second pop-up question. And this is a question that we're going to talk about. Have you updated your definition of education program to include virtual and online spaces? Because the Department of Education has said that education programs and activities can include not only classroom buildings and libraries, but also campus tours, school buses, official field trips, vocational resources, public lectures or events, sporting events, and then computer networks, digital platforms, and other software used in the operation of schools, including when used on a personal device. And here it comes back to that question of substantial control. For example, do you have substantial control over Google Classroom, over a message board that is hosted on another platform? Maybe. Do you have substantial control over TikTok? Probably not. So let's look at that substantial control variable and see, is it a space where there is active participation or supervision by someone who represents the recipient? Or is it a space where students from your school or employees from your school are incidentally interacting outside of the context of schoolwork? So a number of you said, yes, you've updated your policies. A number of you said, I don't know. I think that this is another thing that's come to light more as we have done virtual learning, as we've started to use digital tools a lot more, as the rise of the use of educational apps or online learning has really come to the fore. We've started thinking more seriously about when those apps or that interaction is an extension of the classroom and the education program and activity. And again, there's no kind of set threshold or bright line answer, but it's important to think about those interactions as well. What is someone, oh, Michael?
Yeah, I just want to add to that, Julia. So in the career tech setting, if the school district enters into work-based learning, cooperative education, work study with outside employers, and the employer says, for example, well, we only want to accept boys into this particular work-based learning opportunity, that squarely falls within Title IX. That here it is the school district offering its students the opportunity for work-based learning, but they're dealing with a employer that may or may not be discriminating on the basis of gender, that would squarely fall within the domain to say, no, that would be a violation of Title IX, and we cannot do business with that particular employer. Also, for those of you that are familiar with your vocational or career tech offerings, the Tennessee Department of Education also conducts periodic monitoring of school districts to assure compliance with Title IX in career tech education programs. That is a legal requirement under what's called the OCR guidelines for eliminating discrimination in vocational education on the basis of race, gender, and disability. So again, I just wanted to put that out there for everyone, Julia.
Great, thank you. Yeah, and I think Michael gave us a perfect example for our next slide, which is how do you get someone who is attempting to participate in a program? Well, it's someone who wants to participate in an aspect or element of a program, but is not able to, for example, in the case of a work-based learning employer who says that they only take students of a particular gender. So someone is attempting to participate as well when they have withdrawn due to the alleged conduct and express a desire to re-enroll if the school responds appropriately. If they have graduated but intend to apply to a new program or participate in alumni programs or activities. If they're on a leave of absence and are still enrolled as a student or intend to reapply, have applied for admission. And then if a complainant is not attempting to participate, the Title IX coordinator may still file a complaint based on actual knowledge of a pattern of alleged misconduct. And I think we just discovered how long I have to be sitting here for the lights to turn off automatically in my office. I apologize for the lighting change. So then let's turn to our next topic here. We've talked about when it's not your responsibility to respond to a complaint or an incident, but how do we know when it is your responsibility to respond? The regulations essentially serve as a minimum or a floor for the expectation to respond. A recipient has some discretion to respond to reports that don't quite fit within the scope of conduct covered by Title IX. Remember, we said that if something is outside your education program or activity, if it's not sexual harassment as defined, you can still have a code of conduct that is much more expansive than just Title IX. It should be, right? Because Title IX only covers a small aspect of conduct. It doesn't cover academic honesty. It doesn't cover day-to-day infractions between students. It doesn't cover what happens if one kid throws a snowball at another kid's face, right? So your code of conduct should be much more expansive than Title IX, and just because something doesn't qualify for action under Title IX does not mean that you can't take action. It also doesn't mean that you can't take ideas from Title IX. There's a concept called supportive measures, which is what is offered to students kind of pending the outcome of a Title IX complaint, and those may still be offered. You should follow your own processes for allegations of sex discrimination that are not covered by the rule. For example, those that occur outside of the scope of the education program or activity. But broadly, the recipient should minimize the potential for such acts to occur, and when they qualify for Title IX, stop them when they are occurring. A recipient with actual knowledge, and we'll talk about what that means, of conduct that could constitute sexual harassment must respond promptly in a manner that is not deliberately indifferent. Now, this bar is pretty low. It's deliberately indifferent only if the recipient's response is clearly unreasonable in light of the known circumstances. So again, there's a lot of space between what is reasonable and what is clearly unreasonable and deliberately indifferent. And so this gives institutions and recipients a lot of latitude, but I don't want to get too hung up on this because this is one of the elements that I'm fairly certain is going to change in the forthcoming Title IX regulations. I do think that they're going to raise the bar a little bit for you here and require you not just to be not deliberately indifferent, not ignoring things entirely. But I think they are going to start requiring some consideration of affirmative action or taking some steps to avoid conduct. What is actual knowledge? This is one of those places, right, where the Title IX rules apply differently for colleges and for K-12 institutions. Actual knowledge is notice of sexual harassment or allegations of sexual harassment to a recipient's Title IX coordinator, to any official who has the authority to institute corrective action, or in an elementary or secondary school, any employee. Employees must then report it to the Title IX coordinator. This is going to look a little different from the requirement of mandated reporters in instances of child abuse or neglect, where you have requirements and obligations at the state or local level that generally apply to teachers and school health officials. This is going to be any employee of an elementary or secondary school. And it's knowledge of behavior that could constitute sexual harassment. That employee does not have to be sure. Your lunch staff, your cafeteria supervisor, your classroom aide may not be able to say confidently, this is sexual harassment as defined in Title IX, right? We don't expect that. But if they have concerns that something could meet that definition, then we'd want it to be reported and considered. Actual knowledge can be through an oral report by a complainant or anyone else, a written report, personal observation, a newspaper article, an anonymous report, or various other means. But it cannot be a rumor, an assumption based on behavior, or knowing something to be true. And this is a place where I think the Department of Education really wanted to put kind of air quotes around knowing something to be true. This has to be based on observation, an oral report, a written report, or other more solid means.
Okay, Julia, so we haven't been getting many questions, so let me ask you a question.
Yeah.
A student typically walks to school in the morning, and this particular student is being subjected to sexual harassment, but is reluctant to come forward to talk to his or her teacher.
Mm-hmm.
But another student who happens to observe it does come forward and notifies the teacher about what's going on.
Right.
Is that a basis to notify the Title IX coordinator?
Well, I think you've got two questions here. The first is, if another student observes it and reports it, is it still actual knowledge? And the answer is yes, as long as they report it to an employee of the K-12 entity. The other question, though, is if a student is walking to school, does that constitute an education program, an activity? And it's pretty unlikely, unless the student is being supervised by a school-employed crossing guard, for example, unless they're on school property. I think it would be hard to suggest that that is an area where the LEA has significant control.
Okay, but would you distinguish that from harassment on a bus going to school, where the child is not walking to school, but the child is on a bus going to school, but that child does not come forward, but somebody else on the bus does?
Yeah, so I think that in that case, assuming that it is a school bus, that is a bus that is hired and run by the LEA, if another student, again, this is an oral report of sexual harassment by someone else, comes to a recipient's employee, then there would be an obligation to at least respond in some way. That doesn't mean you have to get through all the grievance process, but it triggers the obligation to review and take it seriously.
Thanks.
Yeah. So any school employee is very broadly defined for the K-12 context. That means teachers, teachers' aides. Bus drivers are tricky because in some districts, bus drivers are independent contractors. In some, they're directly employed by the district or school. I think you'd have to look at what your district situation is. Cafeteria workers, counselors, school resource officers, maintenance workers, coaches, athletic trainers, or any other school employee. Melissa has a great question that says, if another student reports actual knowledge of a situation, but the student or victim in question does not wish to pursue a Title IX report, what is the correct way to approach the situation? So Melissa, you have unknowingly led me into my next couple slides, which is there is an element, right, where the student, or in this case, the parent or guardian, can make a decision, and they can make a decision to pursue a formal Title IX complaint, or they can be offered and they can choose informal resolution. As the recipient, especially in a K-12 context where you have vulnerable students, I would suggest that your policies lean on the side of being open to the Title IX formal process more often than not, assuming that it meets all other requirements, simply because there is some age-appropriate consideration that may not necessarily be top of mind. There may be some language barriers, and you always want to make sure that your students are given the opportunity to be heard.
So, Julia, going to this slide on what is a school employee, how would you respond to a resource worker, a counselor, whose relationship to the school district is a 1099 contractor versus a W-2 employee?
Right. So if somebody is not technically an employee, then technically it's not clear that this would apply. However, I again think it's very difficult for students to know the difference between whether their school nurse is a 1099 versus an employee of the district. No 8-year-old is going to go up and ask a teacher for a copy of their W-2. So again, let's have our policies lean in favor of reporting and filing a complaint. And certainly school counselors are someone who could say, well, even if I'm not an employee, I still think it's important to elevate this concern or this issue and let the Title IX coordinator determine if it is appropriate for investigation. The employee's obligation, unless they're the Title IX coordinator, is really to make sure that this information gets in front of the right people. And I would like this obligation to be more expansive than not. So what happens next? To your question, Melissa, actual knowledge triggers an obligation to respond. The K-12 employees report to the Title IX coordinator. The Title IX coordinator has to determine what supportive measures, if any, are needed, coordinate the filing of a formal complaint if that is desired, and then coordinate the grievance process if there is a formal complaint, or the informal resolution process if the student chooses not to file a formal complaint. In this idea, these are some principles that are laid out in the regulations. We want the response to an incident to treat parties equitably. We want to be sure that we're not just taking one person's word for it, but that we are taking their concerns seriously. We don't want to burden an individual's constitutional rights, their First, Fifth, or 14th Amendment rights, and these are all named in the regulations. That's free speech, self-incrimination, and equal protection, respectively, in response. And then we want to follow an investigation and grievance process that aligns with the Title IX rules before any sanctions are imposed, and then reach a reliable responsibility determination, a determination that we feel is the best possible determination or decision based on the circumstances and the information that we have. But we approach this process with a presumption that the respondent is not responsible for the alleged conduct until a determination is made otherwise. Now, I want to flag a note of caution here, because even though we're not assuming that a respondent is responsible for the conduct, that they did the thing that is being complained about, we still want to take steps that if the incident is correct, if the response or if the complaint is true, that responds meaningfully to that conduct, that prevents it from happening again, that treats the complainant and the respondent equitably, kindly, that responds to their potential needs or concerns until a determination is made otherwise. We also want to be sure that there is no retaliation. And you may remember, if we go all the way back to that pie chart, that retaliation makes up a little bit more than 10% of the complaints fielded by the Department of Education. Because even though a decision may be made, that doesn't mean that people aren't mad about it. So you cannot, no recipient or other person within the recipient may intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege secured because the individual has made a report or complaint, testified, assisted, participated in, refused to participate in an investigation, proceeding, or hearing. So a person can express an opinion, that is allowed, but retaliation is when it rises to the level of verbal threats, harassment, physical violence, or in the context of an employee adverse employment action in response to someone having filed a complaint or participated in or testified in this kind of hearing. I mentioned making sure that we support students and take those complaints seriously. This concept is referred to in the regulations as supportive measures. These are non-disciplinary measures, so they're measures to support the complainant and not the person that the complaint was against necessarily, but we can apply supportive measures sometimes to both parties to protect the access of both parties to educational programs, protect safety, and deter sexual harassment, both during the disciplinary process or even in the absence of a formal complaint. Ed strongly encourages the use of these measures, and if they're not provided, then there needs to be documentation of why that decision isn't clearly unreasonable. In other words, they think that these are pretty easy steps for you to take, and if you don't take them, there needs to be some consideration about why it's not the right move. Those supportive measures must be free of charge and must remain confidential to the extent possible. And some of the examples are outlined in the regulations. They include changes in class enrollment, counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules or locations, campus escort services, housing changes, no contact orders, increased monitoring of certain areas, leaves of absence, or other similar measures. The only one that wouldn't necessarily apply to you as K-12 schools is housing changes. That is intended to apply to the higher education context where the entity provides housing, right? You do not have to help a student move from one house to the other if there is an incident here. But changes in classes, extensions of deadlines, increased monitoring, leaves of absence, those are all things that can be provided in the K-12 context and that should be provided per Ed's view. So the context of Title IX really separates out the informal complaints where no formal documents are filed, where we don't trigger the next few steps, the next slides of this presentation, or supportive measures should be offered, but there's no further obligation. We want parties to be treated equitably in that context. We don't want impingement on constitutional rights, but it's very different from the formal complaint, which is what triggers the Title IX grievance process. Yeah, Alyssa, I'll get to that in just a second. So a formal complaint requires a document signed and filed by a complainant or Title IX coordinator alleging sexual harassment against a respondent, requesting that the recipient investigate the allegation, and that triggers the grievance process. So this can be a form, right, alleging that sexual harassment occurred and requesting that the recipient investigate. That can be a form that is filled out by a student. They don't have to generate all of this information on their own. Again, we're talking about reducing barriers, and that starts us down this process. Alyssa had a great question about supportive measures for the alleged harasser. So I think in this case, it's not necessarily that we are supporting a person's behavior, but supporting this idea that there's a presumption of innocence, a presumption that they did not necessarily conduct the behavior as well as as long as we go through this process. So that means that we don't kick somebody out pending the outcome of a hearing. It could mean that we change everybody's class schedule. It could mean that we take a look at the class schedules and say, okay, it's easier to change this person's class schedule because they need this specialized elective so that they can participate in the advanced physics competition that they're doing, right? We may want to balance those things. We may want to modify someone's class location. We may want to provide the complainant with a leave of absence because they're suffering from post-traumatic stress disorder, because they have a physical injury, but we would not do that with the alleged harasser. But we could certainly modify their schedules. We can provide that person with a leave of absence if they say, for example, I'm really embarrassed by these allegations. It's become really hard for me to attend school. This is a place where we want to listen to students and see what makes the most sense as we take allegations seriously, protect students' access to educational programs, and really listen to what makes them feel safe, ensuring that we're taking it seriously. Is this the process we would take for students as well as adults? Is the process the same for an adult? Yes. And you'll hear me use the term student because the regulations are so student-centered. But Brooke, you're absolutely right. This is the same process we would follow for adults as well as students. A complaint, an adult at a school would be able to know who the Title IX coordinator is and would probably want to go directly to that person. Maybe they don't want to tell as many other people about it, or maybe they wouldn't feel comfortable going to that person. You might find that a teacher's aide would want to tell the teacher that they work with most often about an incident that made them uncomfortable. So the steps are all the same. The protections are the same. You can offer a teacher or an adult a leave of absence. You can offer them class changes, schedule changes, location changes. You don't have to broadcast why you're doing it. You don't have to say, we're moving Mr. Smith's classroom down here because Miss Jones says he makes her feel awkward, right? You just have to say, hey, we're doing this supportive measure only when it's absolutely necessary. So it is the same process, but statistically, based on the language of the regulations, it's mostly centered around students. So you'll hear us use that phrase a lot. So we are at the investigation and grievance procedure point in the process. We've had an incident that may constitute sexual harassment. We've had a complaint that constitutes actual knowledge. A student has decided to file a formal complaint, and we've instituted any supportive measures that are necessary and practical. Who are the important parties in this discussion? But first, we have another attendance question. Do you have a formal investigative or grievance process? Let's see how folks are responding. Looks like the vast majority of you say yes, that's great. So these are the important parties to that process. A complainant, the person making the complaint. A respondent, the alleged person who has allegedly conducted the activity in question. Respondent is just simpler to say. You can have advisors, they're not required. They may be attorneys, they don't have to be attorneys. Generally, they're folks who help a complainant and or respondent get through the process. You have to have an investigator and you have to have a decision maker. The decision maker cannot be the same person as the investigator and cannot be the same person as the Title IX coordinator. And then the recipient is the general term for staff acting on behalf of the institution or entity. So the investigator, the decision maker, and the Title IX coordinator here are all representatives of the recipient. And those are really the three people from the recipient that are important to the process. The elements of the process are a good outline or a good starting point for your policies and procedures. You need written notice to both parties. You need the opportunity to select an advisor, review and submit evidence, use trained personnel to investigate and evaluate all evidence with an appropriate evidentiary standard. We're going to talk about all of these in detail. We're going to talk about what a good evidentiary standard is. Conduct a hearing or question and answer process within reasonably prompt timeframes with a notice of potential sanctions and supportive measures to be offered. Sending both parties a written determination at the end of the process with an opportunity to appeal. The recipient must effectively implement the remedies required, and then document and keep all records of reports and investigations. And
so, Julie, you see Carol's question. Can the Title IX coordinator also be the investigator?
Yeah, Carol, that's a good question. The Title IX coordinator can also be the investigator. You are correct. Yep. And we'll talk at the end. I have a really cool chart talking about who can also serve as what.
And then, Julia, the regulations use the term advisor, which clearly means that it does not have to be an attorney. It could be somebody other than an attorney. Could the policies and procedures require it being just an attorney to advise either the complainant or the respondent?
No, the regulations say that the advisor does not have to be an attorney, and often the cost represents a barrier to entry. So we want that to be an option. Number one, you don't have to have an advisor. And number two, it can just be someone that the complainant or the respondent trusts or that knows the process. They do not have to be an attorney because we do not want cost to be a barrier.
Okay. And do you see Selby's question?
I do. There's a couple of good questions here.
Right.
If a student makes a statement that they are being sexually harassed, they are not going to understand what a Title IX complaint is. Do we call the parent and see if they want to file a complaint on behalf of the student? What if the parent does not want to file, but the student does? So I think this is a really good question when it comes to age and developmental appropriateness, especially in the elementary context. The parent can file a complaint on behalf of a student. That is part of the preamble and the regulations. So if you have a student, particularly a young student who comes to you or that you hear of some behaviors that you're concerned about, yes, I think it's probably a good idea to contact the parent and see if they want to file on behalf of the student. The regulations do not address the question of who overrules, but if they're a parent or a guardian and they have authority, likely your policies and procedures will lean in favor of providing that formal hearing, because remember, you have to be not deliberately indifferent. So if you're not going to provide a hearing, you need to demonstrate and record exactly what that decision-making process was, including if it was subject to a conflict between the parent and the student. Yeah, Stacy, the Title IX coordinator cannot be the decision maker. Well, we'll talk about the conflicts between various positions a little bit later. And I know I'm hyping up this table, but I promise it'll be helpful. So Chris says, going back a little, with an informal decision by the complainant, do we always inform the respondent and parents that there was a complaint and it has been decided to be handled informally, then let the school handle it from there? That is going to be up to your own internal disciplinary policies. When there is no formal Title IX complaint, you kind of exit the Title IX regulations and you defer to your own disciplinary policies or informal resolution process. And we'll talk a little bit about the informal resolution process. I do think that the more information you can provide to parents, The more records you can keep of that, as long as you can keep them confidentially, the more you're able to defend against any allegation that you didn't respond appropriately, that you missed something. So I would suggest, yes, that you err on the side of providing that information and keeping those records and letting the school handle it from there. Brittany asks, any examples of facts that meet the elements of an emergency removal of a respondent during the grievance process? So examples of facts, I think that this is really hard, right? Because we want to preserve access to both parties. But for example, if you have a respondent who has been threatening, physically violent, has brought weapons into the premises, I think that would be an issue where there is a safety concern. Certainly, I think in cases of physical safety, that would be where you'd be most likely to find a need for emergency removal. And again, all the language says that you have to preserve access to the extent possible. We know that that's not always possible, so use your best judgment and record contemporaneously why you're making a decision. And then I do think that incidents of physical violence are probably going to be the most likely to trigger that need for an emergency removal. So what is the notice of allegations? It is required upon receipt of a formal complaint to parties who are known. We provide notice of the grievance or the formal process and the informal resolution process. There are you have to state the allegations potentially constituting sexual harassment with sufficient details, including the date and location of the alleged incident, with time to prepare a response before any initial interviews. And include a note that the respondent is presumed not responsible until the process concludes otherwise. Inform parties that they may have an advisor of their choice and may inspect and review evidence. Inform parties of any provision in any code of conduct that prohibits knowingly making false statements or submitting false information, and then updating the notice if additional allegations will be investigated during the course of the process. So this should kind of be a checklist for you as you go through this process. And Susan, I see your question. We're going to get to that as well. If there is conduct that would not constitute sexual harassment as defined in the regulations, the conduct did not occur against a person in the United States, or the conduct did not occur in the recipient's education program or activity, the recipient must dismiss the Title IX complaint. Now, Susan, this kind of gets to your question, which is, this is the dismissal of the formal Title IX complaint. This means that under Title IX, the school can't discipline the alleged perpetrator. But let's say, for example, that someone files a complaint saying that another student copied off their paper. And they did it because she's a girl and everyone knows that girls are better at math. And so she says, this is discrimination on the basis of sex. I'm going to file a complaint. So you would have to dismiss because that conduct would not constitute sexual harassment as defined in the regulations. However, that could be an academic dishonesty complaint. So the school could discipline the perpetrator after following your academic dishonesty disciplinary policies. So it simply means that you don't use those Title IX procedures, but it does not mean that the student is excused from responsibility entirely. When the allegation potentially involves a crime like sexual assault, can you speak to the investigation as it pertains to law enforcement? So this is going to be a completely separate investigation from whatever law enforcement may do. Law enforcement may conduct a separate investigation. They may decide to wait. They may ask you to wait. You should continue with your responsibilities unless instructed or requested otherwise. Knowing, however, that information that you produce as part of a Title IX grievance process may be requested as evidence or as informative in a law enforcement context. So this is entirely separate. You do not have to be a law enforcement detective, and you must conduct this investigation whether or not there is a criminal investigation.
So to be clear, Julia, if the police are involved, that does not mean that the Title IX coordinator should stop the investigation.
That's
They
correct.
should only, if they're instructed by the police department to stop. That's a different story. But clearly, that is not a reason to pause the investigation.
Right, right. Because the potential consequences are different too. A local judge would not necessarily impose the same kinds of supportive measures or sanctions that a school would. So you're looking at different solutions, different requirements. A recipient may dismiss a complaint if the complainant withdraws, if the respondent is no longer enrolled or employed by the recipient, or if specific circumstances prevent the recipient from gathering evidence. So I think this is a case where the involvement of law enforcement may lead to potential dismissal if the involvement of law enforcement, for example, prevents you from gathering evidence, and could do so because they have all the evidence, or because the respondent is being detained, right? Those are circumstances where you could dismiss, but again, keep all your records, make sure it's done thoughtfully, and then in any case of dismissal, have to send a written notice including the reason for dismissal. So Alyssa asked, there's a sexually oriented media post over the weekend and the parent files a sexual harassment complaint at school on Monday. Is this not considered since it's not during an education program or activity? So we would look to what platform was used. And I know that that is a very kind of tech answer. However, if the school exercised substantial control over it, for example, if it's something like Class Dojo, if it's a Google Classroom, where it is part of the educational activity and students are expected to be there, then I would consider you to have some responsibility. However, if it is TikTok, Instagram, Snapchat, anything where you don't have engagement or substantial control, then you are not responsible. If you need to get to the investigation point, the recipient is responsible for conducting the investigation. This can include a review of the evidence that has been provided by the respondent or the complainant, interviews, site visits, and other information gathering. All burden for information gathering sufficient to reach a determination does rest on the recipient, but the recipient may not restrict either party from discussing the allegations or from preventing evidence. Parties have to have written notice of the time, location, and participants and purpose of all hearings, interviews, or other meetings with sufficient notice to prepare and participate. That does not mean that the complainant has to be present during a respondent's interview, but if that's going to be part of evidence, we want to make sure that they have all of the information needed so that they can present counter evidence. They have to have the equal opportunity to present inculpatory evidence, meaning something to prove the respondent committed the alleged incident, exculpatory evidence that is offered to prove that they didn't, fact witnesses, and expert witnesses. Parties must also have the opportunity to inspect and review any evidence, even if the investigator does not intend to rely on it. Once the investigation is done, the investigator must complete an investigative report that summarizes results and offers any recommendations or conclusions that is sent to each party and any advisors, along with a record of that evidence. provide 10 days to review and offer a response, and then any responses should be considered prior to the completion, prior to marking it final. If the respondent says, you went to room 613, but actually I live in room 313, we still want to correct that evidence because maybe it has to do with who was next door or who might have heard something. So we want to be sure that those responses are considered before the investigative report is final. The report must be completed and provided at least 10 days before any hearing or other determination so that parties have the opportunity to respond. We are actually going to come back to the topic of the investigative report closer to the end of this training. Once the investigative report is completed, there is a possibility of a hearing or question and answer. A live hearing is not required in the K-12 context. It is permissible, but if you're a college, you would have to conduct a live hearing. Where hearings must be live, they can be in person or virtual. In the K-12 context, you get to decide. You don't have to make one blanket decision for everyone, but you can decide whether in one incident it makes sense to have a live hearing or to have written questions and answers. And that will depend on the severity of the conduct. It'll depend on the parties involved. It'll depend on the emotional and otherwise maturity of the parties involved. There was a piece about cross-examination, which said that if parties do not submit to cross-exam, the decision maker could not rely on their statement. But a federal court actually vacated that provision in July of 2021. So if that is part of your rules, you should take that part out, right? So just because someone doesn't submit to cross-exam doesn't mean that their statement is not reliable. A refusal to be cross-examined alone may not lead to determination. And then respondents must create an audio-visual, or written record. This means a recording or a transcript. This does not mean put it on YouTube. We have to keep these confidential to the extent possible. I also want to talk about sexual and medical history. This is probably one of the trickiest concepts within the Title IX rule. It mirrors something called the Federal Rape Shield Law, and that is a tricky topic for lawyers. It's something that evidence professors will spend days talking about because there's a lot of nuance to the rule. And here's how it is presented in Title IX. It's that questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant unless such questions and evidence about the prior sexual behavior are offered to prove that someone other than the respondent committed the conduct alleged by the complainant, or if the questions and evidence concern specific incidents of prior behavior with respect to the respondent and are offered to prove consent. So prior sexual behavior is sexual behavior that is unrelated to the alleged conduct. That means that we don't want to say a particular student is lying about conduct being unwelcome because everyone knows that they make out with everyone, right? We don't want to be use as evidence or bring into question in a hearing any other behavior outside of this particular context we're talking about. We don't talk about their reputation. We don't talk about their prior behavior as a general rule. Whether prior behavior is relevant to prove consent, in other words, prior behavior with respect to the respondent. If student A says student B assaulted me, and student B says it's not assault because we've done that before, how does that align with your code of conduct? Does your code of conduct require verbal expression, for example, before sexual conduct in each and every instance? So that will depend on what your policies are. Generally, questions about medical, psychological, or other records are not permitted unless the party has given written consent, and then the recipient must abide by relevant healthcare and educational privacy laws. So if you have medical records, you must comply with HIPAA and FERPA with respect to keeping those records confidential. Why are these questions prohibited? A lot of it gets to concerns about bias. To prohibit the use of evidence of a complainant's sexual reputation to prove consent, to prevent the use of sexual history evidence to establish complainant as a type of person who is more likely to consent to sexual activity. In other words, to downplay some allegations. To exclude the use of a complainant's sexual history as an indicator of truthfulness. Do we say, we don't want to be able to say, this person isn't telling the truth because they do this all the time or because they've done this before, and to avoid prejudicing the decision maker. The whole process should ensure that there's a presumption that the respondent is not responsible for the alleged conduct until a determination regarding responsibility is made at the conclusion. So we want to frame the whole process in such a way to treat both parties as truthful. A presumption does not imply that the conduct did not occur or that the complainant is untruthful. It's intended to promote impartiality and should have no impact on the supportive measures offered. Treat everybody equitably with the idea of preserving access in mind. For the standard of proof, how we determine whether someone is responsible for conduct, the recipient can choose to use one of two standards, either preponderance of the evidence, in other words, is it more likely than not that a respondent committed an alleged act, or clear and convincing evidence. In other words, is it highly probable that allegations are true? The recipient has to use the same standard for both students and employees and must use the same standard for all formal complaints of sexual harassment. This standard is one of those elements that may change when we get new Title IX regulations. But for the time being, you should stick with one of these two standards as you have selected them. After the hearing, the decision maker has to make a decision. They have to make a determination of responsibility and must issue that determination simultaneously to both parties. That determination must include an identification of allegations, a description of the procedural steps taken, notifications, interviews, hearings, etc. This is both to ensure that both parties were included equitably in the process and for your own record, so that you are able to demonstrate that all of these steps were taken and that everyone was notified. The findings of fact that supported the determination, conclusions regarding the application of the recipient's code of conduct to the facts, the rationale for the result or the decision to each allegation, including a statement of result, a determination of responsibility. That means, was the respondent responsible or not whose fault it was, any disciplinary action, and any remedies and responsible party for those remedies. For example, for the recipient, the Title IX coordinator will implement those remedies. It also must include procedures for appeal and any permissible bases for appeal. Remedies are required to be provided to a complainant where the respondent is found responsible. They must be designed to maintain the complainant's equal access to education and may include the same individualized services that were offered before. They do not need to be non-disciplinary or non-punitive. They do not need to avoid burdening the respondent if the respondent was determined to be responsible for that conduct. So you can discipline, punish, burden the respondent if they are determined to be responsible, but only at that point. There must be the potential for appeals, and both parties must be offered the ability to appeal. They must be offered the ability to appeal after the determination of responsibility or after a dismissal of the complaint. And they can appeal on the basis that there were procedural irregularities, that there is new evidence that was not reasonably available at the time, that there is a conflict of interest or bias among the Title IX coordinator, investigator, or decision maker. So those are the reasons that we would see an appeal. An appeal would not be, we don't like the decision. It would be, there were problems with the process. The recipient must notify the other party in writing when an appeal is filed, as well as the procedures that apply, and those procedures must apply equally to both parties. There has to be a new decision maker. You can't apply the same decision maker to both parties. That decision maker may not be the same one as in the original hearing or determination, the investigator, or the Title IX coordinator. Must ensure the decision maker follows the same processes as outlined in the original grievance process and give parties a reasonable, equal opportunity to submit a written statement in support of or challenging the outcome of the original determination, and issue a written decision describing the result of the appeal and rationale, as well as providing the written decision simultaneously to both parties. Katie, you ask a really good question, and I'm going to start by saying that the answer to this is not really clear. The question is, student disciplinary records are covered by FERPA. Does the determination override that? In other words, does the determination where you lay out what the consequences are override the requirement to keep disciplinary records private? This is actually a question that has gone to federal courts. There was an incident at Georgetown University in 2001 where a student complained about assault by another student, was not told what the sanction would be, and complained that this caused her anxiety and caused her to lose access to the educational programs because she was so concerned about running into the person who had been found responsible for sexually assaulting her. And a court basically said that the college could tell her about those disciplinary actions in the determination, even though they said that that information was protected by FERPA. So in general, it's not addressed in the regulations, but in prior legal decisions, courts have said that this specific requirement for notice trumps the more general protections under FERPA. So let's get back to the informal resolution process, right? If a complainant doesn't want a formal hearing, if they don't file a formal complaint, if it is conduct that does not rise to the level of triggering Title IX, we can have an informal resolution. That can't be required as a condition of enrollment, continuing enrollment, employment or continuing employment, or any other right. It can't be a condition of waiving the right to the investigation or adjudication. It can't be required by the recipient and may not be offered unless a formal complaint is originally filed, right? So this has to be a situation where the complainant changed their mind or there was another reason why we need to transition to informal resolution. It also can't be offered or facilitated to resolve allegations that an employee sexually harassed a student. In that case where there is a Title IX complaint, there needs to be a formal resolution. A recipient may facilitate an informal resolution process at any time, which does not involve a full investigation and adjudication. The recipient must provide a written notice of allegations, the requirements of the informal process, the circumstances under which it precludes resuming a formal complaint, the right to withdraw at any time, and the consequences resulting in the informal process, including what records may be created that will be maintained and shared. The informal resolution process requires voluntary written consent from both parties. The regulations say that this process should look something like mediation, but otherwise they don't describe it, and they really rely on the recipient's pre-existing policies and procedures to resolve this situation when you've kind of moved away from the formal Title IX, right, where you're not covered by any of these prohibitions, you've decided, or there's been a determination that the formal grievance process doesn't apply. We just kind of slide into your recipient policies. Yeah, Selby, thanks for this comment. Law enforcement is pulled in for our investigations initially to ensure that there is not an LE investigation that needs to occur. Once they give us the all clear, we move forward with our Title IX investigation. Yeah, as long as this is happening in a timely manner, in a way that does not impede access to either the complainant or the respondent, I think that's a great example of cooperation. Thanks. Record keeping. Maintain records for 7 years. That is the bottom line of this very short section and the 2 slides contained here. Maintain all your records for 7 years, including for allegations, including determinations, recordings or transcripts, any sanctions, any remedies provided to restore or preserve access, appeals, results, informal resolutions and results, and then materials like this used to train Title IX coordinators, investigators, decision makers, and facilitators. Is it daunting for me to think that you could be listening to this 7 years from now? A little bit, but I'm going to tell you to keep it anyway. Other records that you have to keep for 7 years. Each incident of actual knowledge not taken to the formal grievance process or informal resolution. Record any actions, supportive measures. If none, document why the lack of supportive measures was not clearly unreasonable in light of the circumstances. What is your basis for any conclusion that any lack of response was not deliberately indifferent? Part of the way that you support that action is outlining the measures taken to restore or preserve equal access for the complainant and the respondent. This is the last couple topics here. So if you are one of the people involved in the Title IX process, how do you serve impartially? In the regulations, ED requires that your training cover how to serve impartially, including by avoiding prejudgment of the facts at issue, conflict of interest, and bias. But the regulations don't actually go into any more detail. The preamble does a little bit, so we'll talk about what it says here. That means not relying on sex stereotypes, promoting impartial investigations and adjudications. The decision makers must be trained to serve impartially without prejudging the facts. So if you're a decision maker, you have to come in with an open mind. There's also this requirement for impartiality applies to investigators, decision makers, Title IX coordinators, facilitation coordinators, if you're someone facilitating a hearing or informal resolution, and other Title IX personnel. It does not apply to advisors. Advisors do not have to be impartial. That is their job. They are there to promote the best interests of their advisee. Professional experience, gender, or affiliation does not negate an ability to serve or to be impartial. A decision maker is not, by definition, partial to one person or another because of their professional experience, gender, or affiliation. We care about this because we want processes to be reliable, legitimate, impartial, accurate, truth-seeking, and rooted in due process. We want to make sure they are perceived as such. And so making sure that we are impartial, that we're not demonstrating bias, helps with that perception. It also helps us to be sure that we're making a good decision and helps us feel confident that the resolution reached is appropriate. We also want to avoid the perception of bias. That's defined in the preamble as, for example, treating a party differently because of that party's sex or stereotypes about how men and women behave with respect to sexual violence. Ignoring, blaming, or punishing a student due to stereotypes about the student would be considered bias. And we don't have to limit this to bias about a student's sex. Bias can be against an individual's sex, race, ethnicity, sexual orientation, gender identity, disability, immigration status, financial ability, socioeconomic status, or other characteristics. In other words, we can't say that we believe a person is more likely to have committed sexual assault because of their national origin, or less likely because they have a disability. We have to make sure that we are listening to the facts and not making assumptions about responsibility. In other words, would a reasonable person believe bias exists? Are we projecting an image of impartiality and non-bias, or would a reasonable person looking from outside the process have concerns about the process? That's kind of the approach you want to look at. So look for equal access to evidence, documents, and appeals, the ability to cross-examine equitably, a pause during live hearings to consider the relevance of each question before it is answered. We want to be sure that we're not just on autopilot. Ensure that no party or witness is asked questions in an abusive or intimidating manner, and avoid prejudgment or decide cases based only on the facts at issue. You as a recipient should have some kind of rule of decorum for your hearings or other disciplinary processes that would help reflect some of these principles. The principle of impartiality also applies in evidence. The investigator making recommendations or credibility determinations, if they are doing so, that could lead to allegations or concerns of bias. If the investigative report says, I really don't believe so-and-so because XYZ, that would be a concern about bias. We just want the facts in that report. The decision maker should not disallow relevant questions from being answered. We know some of these decisions are going to be tricky because we're making these decisions about relevance, and that's a hard concept. But if a question is relevant, it should be allowed to be answered and considered. A decision maker should not discount inconsistencies or errors made by a complainant while relying on similar inconsistencies and errors made by a respondent. I think that this is a very legal way of saying we should recognize that people are fallible and we should treat them equitably when it comes to trusting their recollections. Make sure that if we are concerned about inconsistencies, we're concerned across the board. Avoid prejudgment by avoiding relying on sex or other stereotypes, and listen to all information provided without discounting a witness, respondent, or complainant. We need to talk about conflict of interest. That is one of those things that regulation says you have to be trained in, but it doesn't say what they want me to tell you. That's not defined except where an individual can't fill multiple roles. We should note that you are allowed to fill Title IX roles with employees and internal personnel. Personnel from the same office can fill different roles in a case or hearing. So you can have people from a student conduct office who one person is the investigator, one person is the decision maker, one person is the Title IX coordinator. That's okay. You don't have to go outside of that district or of the state and hire a neutral decision maker. You certainly can. It is not required. But the idea is that we want to make sure all of these people are able to serve impartially and without bias, and that we're not concerned about whose interests they're representing with respect to a particular incident. So this is the chart I was hyping up earlier. Can your Title IX coordinator also be your investigator? Yes, they cannot play any other role in the process. Your investigator cannot be your decision maker, cannot be the decision maker in the appeals process. It is just the Title IX coordinator and the investigator that can overlap here. Note that you need at least 3 people in this process designated. You have to have the Title I coordinator, and they may be the investigator. You have to have the decision maker. And then if there is an appeal, you have to have another decision maker who makes the decision about that appeal. So you have to make sure that all of those people are thoughtfully designated, avoiding conflicts of interest, knowing that they've all been to a training like this on the ability to serve impartially and bias. This is our last one before we talk about potential changes, relevance, and investigative reports. We talked about the investigative report earlier, and you're probably saying, why didn't we just cover this then? I'm just going in order by the regulations. We're covering all of these items. We're checking the boxes. This is in 106.45B57. The recipient has to create an investigative report at least 10 days prior to the hearing or other determination. We know that. That report has to fairly summarize the relevant evidence. It has to be sent to each party and the party's advisor, if any, in an electronic format or hard copy for their written response and review. The investigator will consider that response prior to the completion of the report. We know all of this. That subsection, though, goes into a little bit more detail. The burden of proof and gathering evidence sufficient to reach a determination rests on the recipient. So the recipient is the one who has to make sure that they're doing all of the things, going all the places, talking to all the people. You cannot place the burden of presenting evidence on the complainant or the respondent. The recipient cannot access, consider, disclose, or otherwise use a party's treatment record from a physician, psychiatrist, psychologist, or other professional or paraprofessional without written consent. It is admissible when you have written consent, and it is relevant. Both parties must have an equal opportunity to inspect and review any evidence as part of the investigation, including evidence that the recipient doesn't tend to rely on, and both inculpatory and exculpatory evidence. Recipients must provide an equal opportunity for the parties to present witnesses, including facts and expert witnesses and other evidence at any point during the process, and must not restrict the ability of either party to discuss the allegations or to gather and present relevant evidence. I'm going to answer Katie's question really quick here, and then Cindy, I'm going to come back to you shortly. Does the appeal decision maker have to be named in the policy? No, you don't have to name any of these people in your policies and procedures. We know people change, and it's easier to update a business card than it is a policies and procedures document. But you have to have that person at least be available in concept. You have to know where you can draw an appeals decision maker from. You have to know that they're available. If you have an appeal, you won't always have an appeal, but it is important to recognize that it has to be a different person from the original decision maker and from the Title IX coordinator / investigator. And then Alyssa has a question on evidence. Should you automatically offer evidence to review or just provide them the opportunity to review the evidence? You know, I think that this is a question of what the evidence is and what makes it easier. The regulations only require the opportunity to inspect and review. But, you know, if it is easiest for you to say, here's a link to a Dropbox that contains the evidence or a summary of the evidence that we've gathered, that's probably easier than saying, let me know if you want the link, because at least you can show that you've offered the opportunity and made it easy. If it is, we have a confidential file that's at the police station that you can go and request, I think in that case, you let them know where it is and how they can request it, right? The opportunity is what's required, but let's think about what is the lowest barrier to entry and what makes sense just from an administrative process standpoint. So relevance, we have to consider the relevance of any questions or evidence. Any only relevant cross-examination and other questions may be asked of a party or witness. Before a party or witness answers a cross-examination, the decision maker has to pause. Remember, we talked about impartiality, and determine whether the question is relevant. And relevant here is relevant to whether it is more or less probable that a person engaged in this activity. So this means, does evidence, does a question or the answer to a question have a tendency to make a fact more or less probable than it would be without the evidence? And the fact is of consequence in determining the action, whether the action occurred or whether it was sexual harassment. So we're using a plain language meaning of, is this important to our decision-making process? We don't want to ask questions like, what color were your shoes, unless they are relevant to the decision-making process, like, I saw red shoes from under my door, right? So we want to make sure that all of these questions are relevant, that we don't get off on tangents, that we don't ask questions and seek answers that have a propensity to bias the decision maker against a complainant or respondent. Relevance decisions should not be based on the sex or gender of the party for whom it is asked or to whom it is asked. Either party's status as complainant or respondent, either party's past status, have they filed previous complaints or been the subject of previous complaints, any organizations of which either party is or has been a member, or any other protected class covered by federal or state law, such as race, sexual orientation, or disability. This is another version of all of those impartiality requirements, right? We have to make relevance decisions based on the facts themselves and not who is presenting the evidence or asking the question. Melissa asks, do we redact the names of other student witnesses on statements? It is not required under this rule that you do so. It may be required based on the circumstances or your other policies and procedures. Certainly, if you have concerns about safety for other students who are named as witnesses, there's nothing that says you can't redact their names. However, who a student is that witnessed an event or made a statement may be relevant to determining whether it is inculpatory or exculpatory. So that is something to consider as well. If you have a student who is not well known to the complainant or the respondent and their statement is offered as the truth of something and we don't actually know how they know this, it might be important or relevant to know who that student is. So this is a situation where the regulations are silent. Use your best judgment and rely on your existing policies. Topics that are off limits, questions about a complainant's prior sexual history, unless offered to prove someone other than the respondent committed the conduct. If the questions and evidence concern specific incidents of complainant's prior sexual behavior with respect to the respondent and are offered to prove consent, they can be admissible. Again, this is a tricky rule and proceed with caution. Legally privileged information, including information resulting from legal or medical consultation, is also off limits. And here we're using off limits as a substitute for irrelevant because something like a confession to an attorney may in fact be relevant, but here it is off limits. So for purposes of legal terminology, we'll call it irrelevant. Medical records are off limits unless with voluntary consent, and duplicative questions are off limits. So Cindy asks, have you had a situation where the complainant leaves the school after filing a complaint and is no longer available to interview? What is the best way to handle the remainder of the grievance process? So this one is difficult too, because there are some exceptions within the regulations for situations where a complainant or a respondent are separated from, as in fired by, in the context of an employee, or are no longer attending the institution. If you have reason to believe that this conduct is pervasive and has occurred with other students, then you may have reason to continue the investigation. But I would actually encourage you to review those examples that they give in the preamble, because I think that there is a lot of nuance there with respect to the specific situation that's important to consider. So there's not a bright line rule, especially in this situation, but you do have a couple things to think about. So the last section we are going to cover is, on the 10 days, is that 10 days or 10 business days? It says 10 days. So I would assume that that is just 10 days period. If you would like to be more generous and give them 10 business days to review and respond, I'm sure that is appreciated, but the regulations simply say 10 days. The last thing we're going to talk about, and keep those questions coming because we can certainly respond to them, is what we expect to be the coming changes for the new Title IX regulations. There were draft regulations on this topic, discrimination on the basis of sex in a recipient's educational program and activity, that were published in July of 2022. They received more than 250,000 public comments. My understanding is that this is the most public comments a rule has ever received. Those range from very detailed, substantive, procedural comments from LEAs, states, and universities to, grassroots or what we call AstroTurf advocacy efforts, where individual people signed their name on a website and it sent a comment to the U.S. Department of Education commenting on a specific aspect of the rule, saying that it was too protective, not protective enough, etc. The final version was originally expected in May 2023. You didn't miss anything. It isn't out yet. There were separate draft regulations on athletics published in April of 2023. So we did not talk about athletics at all. That is a different proposed rule. It is a topic that is not currently covered by this rule. Those received 142,000 public comments. Originally, we were told it was going to be May for the final version, then it was October. Right now, the self-imposed deadline from the U.S. Department of Education is March of 2024. As of Friday, the Department of Education had sent a final version of the Education Program and Activities Rule to OMB for final review. OMB is the arm of the White House, the Office of Management and Budget, that holds stakeholder meetings, make sure nobody missed a comma or misspelled a reference or word. They run it by some stakeholders, and then they publish the final version. That takes 8 to 12 weeks in normal circumstances. This is certainly a priority, so I believe that they can meet that March deadline with respect to the education programs rule. I have not seen any new timeline on the athletics rule. That's going to be a different question. The implementation date may be as early as this fall. There is no requirement that the Education Department give you advance notice. The rules we spent today talking about were published in August of 2020 with immediate effect. The goal seems to be to have them in effect for the fall. So let's logistically, mentally prepare ourselves for that. However, many of the proposed changes are going to be controversial, and there will be litigation that is likely going to challenge them and may lead to those rules being paused in some states for some period of time. Let's prepare for implementation, but also prepare ourselves that that may not go according to the timeline. Proposed changes. We've been talking about conduct on the basis of sex, but we haven't said what sex is. So far, Congress and the U.S. Department have not defined it. They likely will define it in this new rule as inclusive of gender identity and sexual orientation, sex characteristics or stereotypes, pregnancy and related conditions, and it will include those attempting to participate in activities like admissions. It will cover some off-campus conduct that contributes to a hostile environment. So when we talk about substantial control over things like websites or apps, we'll also be potentially talking about whether conduct occurs in a context that contributes to a hostile environment at school. It will also likely change the standard for action, not just avoiding deliberate indifference, but an active obligation to respond to allegations of sexual harassment and prevent future harassment. That's the goal throughout these regulations we've been talking about, but the obligation is a little bit different, and it will likely raise the standard, so you have to do more. The athletics rule, this is the proposed rule that was published last year. It is very short. It is only one paragraph, but it has the potential to create a lot of conflict. It says if the recipient adopts or applies sex-related criteria that would limit or deny a student's ability to participate on a male or female team consistent with their gender identity, such criteria must differentiate by sport, level of competition, and grade or education level, and they must be clear on how they're substantially related to the achievement of an important educational objective, and minimize the harms to students whose opportunity to participate on a male or female team consistent with their gender identity would be limited or denied. In other words, districts, states, colleges are going to have to come up with policies that apply or adopt limitations around participation, if any, and those limitations would have to be relevant to the sport, the level of competition, your Division A huge high school programs are going to have a different reasoning from my 6-year-old's Pee Wee soccer team. They're going to have to minimize harms to students who can't participate. This is going to involve a whole fleet of lawyers. This is going to involve litigation from states that have laws that directly conflict with this. So I am less confident that this will go into effect as soon as the education programs and activities rule. So we have just a couple more minutes in our time together. I'm going to close out with some housekeeping as we also give you a little bit of information and resources. Here's a link to the final rule, some PDFs, some fact sheets, and some guidance from the U.S. Department of Education for further reading. And if you scan this QR code, you can fill out a form to get CLE credits. And there's also a link in the chat for that.
Julia, I did not think that you were going to get through all 98 slides. Your timing, as usual, is impeccable. But thank you so much. And I just want to add that as these rules come out, there's going to be need for rewrite of existing policies and procedures, and we're certainly available to work with all the school districts there in Tennessee to help them revise their current rules to comply with the new rules that will be coming out. But thank you, Julia.
Absolutely. And yeah, I expect that that's going to be a lot of work for everyone. And as Michael said, we're so happy to support. So thank you for participating in today's virtual training. If you have any further questions with respect to the information presented or any other questions in general, please feel free to email us at webinars@bruman.com. That's webinars with an S at BRUMAN.com. If you're interested in more information about our virtual trainings, you can visit our website at bruman.com/virtual trainings with an S. And I see some folks from State Department are saying TASL credits are also available for educators. That's wonderful. I think that ends our time here today. So I'm sure that you all need another cup of coffee. After all of that information, the training to Brooke's question is going to be recorded. It is going to be per TOTDOE captioned, so it will be available at a later date. And if you didn't get a chance to download the handouts, you can do that right now, but we'll also make sure that they're made available through the state. Thank you so much, everyone, for joining us. I really appreciate all the wonderful and thoughtful questions today.
Thank you.